Hi, this is attorney Joe McPeek with Virtuoso Criminal and DUI Lawyers. Assault with a firearm is governed by California Penal Code Section 245A2. As a side note, Penal Code Section 245 contains a lot of assaultive crimes, some of which can be charged either as a felony or as a misdemeanor, and that whole family of 245 statutes. For now, I'm just going to talk about subsection 245A2. A person convicted of assault with a firearm under this section could be sent to state prison for a period of 2, 3, or 4 years. But that person could potentially also be given a grant of probation, which may or may not include a stint in county jail, and that county jail period, depending on what county you're in, could perhaps be made eligible for some type of alternative sentencing, like perhaps house arrest or the sheriff's work program. Again, it depends on the county that you're in, and it depends on the facts of the case that are ultimately proven once the case is resolved, whether it's a jury verdict or through a plea deal. Getting straight to the point though, however, we need to talk about what the government needs to actually prove in order to find somebody guilty of the crime of assault with a firearm. In order to prove somebody guilty of assault with a firearm under Penal Code Section 245A2, the government has to prove beyond a reasonable doubt that the defendant willfully did an act that naturally or probably would result in the application of force to another person, and that the defendant knew or reasonably should have known of such circumstances that their actions would or could have reasonably led to the application of force, and that they did this act with a firearm at the time. Now, a couple of highlights there. First of all, when we think of assault, we think of fights, we think of physical injury. Well, to prove an assault, the government doesn't actually have to prove that anybody was physically injured. The government doesn't even have to prove that physical force was actually applied to another person. They only have to prove that the defendant did something that by its nature would have reasonably led to that. So in situations like, quite frankly, your hallmark assault with a firearm case is a shooting. So in that situation, if somebody is shooting at another person and thankfully nobody gets hit, well, it's still an assault with a firearm potentially if the government can prove that the shooting was too close, that it was done intentionally or willfully. Those are situations that could lead to a charge and possibly conviction of assault with a firearm. On the flip side, you can also commit assault with a firearm in ways that maybe you don't think about when you first read that statute. Like I said, when we think of assault with a firearm, we might often think of shootings, but believe it or not, physically using a firearm to strike somebody, like perhaps in a pistol whip, as somebody might say, that is also considered assault with a firearm and is treated just as seriously, at least on its face, as a shooting under the same statute. It's really important when defending an assault with a firearm case to make these distinctions known. If you're in a situation where the defendant looks like they are probably going to be convicted of some type of version of assault with a firearm, it's important to make the court and the DA know that not all versions of this conduct need to be created equal. There's different levels of severity. Different types of shootings might be considered more serious than perhaps using the pistol or the firearm to actually physically injure somebody. And of course, there are other situations where maybe the lack of physical injury or the degree of physical injury might point to the severity or lack thereof. A good defense attorney needs to explore these things. But before we even get to that, as with any assaultive crimes, there's plenty of defenses available. Maybe you're falsely accused. Maybe the person who assaulted the complaining witness has been misidentified. Maybe it's a frame-up or a fabrication. Maybe there's not enough physical evidence to corroborate what the government is alleging. And of course, as with all allegations of physical violence, a good defense needs to look into whether there's an argument available for self-defense or defense of others. If they can prove beyond a reasonable doubt the defendant did fire off a gun, okay, well, was it in response to somebody else shooting first? Did the defendant reasonably believe that they were being shot at or they were going to be shot at, and that's the only reason why the gunfire came out? These are all things that need to be explored thoroughly in the defense of an assault with a firearm case under California Penal Code Section 245A2. Thanks for listening. For more information and additional videos like this, please go ahead and check out our Instagram page and our YouTube page and our law firm website anytime. Thanks, and be safe out there.